appreciate the question. I really do, because normally, in the normal course of civil litigation, that would be what we would do. We've provided the court already with adequate evidence to justify an order to show cause in the circumstances that in the arena we're working in today. This is public records. There's a presumptive openness, presumptive access to public records. We've provided evidence to the court adequate to trigger an order to show cause requiring the sheriff to explain themselves and to do so quickly.
What I'm struggling with is the legal basis, not the factual basis behind the order to show cause. I look at your complaint and I treat everything in there as true for this argument. And there's no dispute about a factual basis for it. But again, there's no preliminary injunction. There's no motion. I mean, what is my legal basis for doing an order to show cause before the pleadings are closed? That's really what it comes down to. What is my legal basis for doing it?
Well, it's the statute, and it's all the case law that goes along with Chapter 119 and Article 1, Section 24 of the Florida Constitution. The presumption of access, presumption of openness, is just it's all over Florida law. It's entrained. It's embedded at every corner. Your Honor, I would like to draw, and I'd be happy to brief that. I'm happy. I understand your question and your concern. I'd be happy to brief that. So, in addition to the evidence we've already provided to the court, we'll provide that briefing. Ms. Moody talked about 47 and a half hours of video from 19 cameras. Yesterday she told me it was 38. We're not sure. So that'll have to be determined. The purpose and the reason the newspaper is doing this, Your Honor, is because there were 5 separate investigations or reviews of the Sheriff's Office response to a very violent inmate that ultimately ended with his death. The narratives of all those reports say one thing. The evidence underlying those narratives say another thing. That's why we need to rip the cover off these reports and let the citizens and voters see what the evidence is. You know, if we are, forgive me for getting a little philosophical here, but if we are to be self-governed, as Thomas Jefferson said we should be, the voters need to have adequate information to make an informed decision about the election coming up in November, about how its elected law enforcement performed in these circumstances. They have that right. That transparency is now, today, more than ever, important. As the evidence we've submitted with the complaint shows, there's a lack of trust in the community of this case and of this sheriff. And so this video is our best opportunity to answer the questions, the disconnects between the underlying evidence of these reports and the narratives of these reports. The video is the last best hope to answer these things. And the assertion of security exemption is, frankly, Your Honor, a bit absurd given the amount of video that the sheriff has released about the booking area and the jail area as well, and other, diagrams, floor plans. If there are any weaknesses in the security cameras in the jail, I'm sure the deputies know where they are. Nobody's trying to break into the jail. Is last I found out, last I've heard. So, forgive me for being a little flip there. I don't mean that. There can be no testimony from the editorial board or reporters. Switching to another subject, Chapter 90.5015 Florida statutes is a reporter's shield law, journalist shield law. So, unless a reporter witnesses a crime, they cannot be called to testify in any proceeding, absent a number of high hoops that the requesting party has to jump through that are set forth in the statute, 90.5015. So they can't be testimony.
Now, if you are to call them as a witness at an evidentiary hearing, does that make a difference? Should the other side be able to depose them ahead of time, find out what they're going to say?
I'd have to look at that, Your Honor. be honest with you, I don't know. I don't know that we've ever done that. And I have no plans in this case to call any of the newspaper people as witnesses. But
Okay.
I'll leave that question open if I may. Judge, and I appreciate your questions. And if I were Ms. Moody, I'd make these arguments too. My experience in these cases is that this is a proper format to stay within the requirements of 119.11. And of course, we'll brief it. This is, forgive me for saying this, this is an arena that a petition for cert would be proper if there was a delay in the hearing or in any order that would require discovery. I don't like to say that because, I mean, there's always the avenue of appeal, and it sometimes sounds as a threat. But I'm not saying it that way. I'm just saying that that's a frequent thing in these types of cases. Now, we'll be happy to brief all of that, and I'd be happy to answer any more questions, Your Honor.
All right. Hold on. Let me make a note. Okay, Mr. Burt, since you're the primary movement, I'm going to let you do the orders. We submit them through the portal, obviously run them past Ms. Moody first to make sure they're consistent with the court's findings. And let me make a statement first that does not need to be reflected in any order. And y'all may know that I'm not working a whole lot right now because I'm recovering from some stuff. But when this came in, I decided I need to set a hearing and I need to take control of it and I need to get it done on a timely basis. And that's my intention. I don't know where the facts are going to take me. I don't know where the law is going to take me. I don't favor Florida today. I don't favor the sheriff. That's not what I do. But regardless, this is a critically important case. Timing is important. The election date is just raised and totally irrelevant to me. But independent of that, this is a critically important case. If the public has a right to know, then they have the right to know, and they need to know on a timely basis. If they don't, they don't. I don't know where the facts of the law are going to take me. But trust me, from our standpoint, there will be no court delay. It won't happen. So, order number one, we've talked about, by agreement, the relevant media will be presented to the court for in limine inspection. Ms. Moody, how long do you think y'all need to get this stuff together and get it to my office? I mean, obviously, go ahead.
That won't take too much time. We'll just need to coordinate how that exchange will happen. We can do that rather expeditiously. That's not an issue. It's just a matter of you telling us where and how you want that, how you want to conduct that hearing.
Well, I'm
really at the discretion on that.
What I anticipate doing with those things is you'll provide it in a readable method, and I will sit down and go through it. I won't have a clerk or anybody else present. I'll personally do it. I don't anticipate any objection to that. That's probably what y'all expected. All right. What I'll have you do is contact my judicial assistant, Monica Gabbard, offline as far as the actual arrangements unique to COVID. People are in and out of the office, but what will happen is that you all will provide walk over from your office to the VR courthouse, presumably, or wherever it's coming from. A judicial assistant will sign for it, and then I'll get it from that judicial assistant so that we can track it. But detail-wise, probably want to wait for the order, but detail-wise, I think just coordinate the actual handover through my JA. Okay, so the order does need to provide appropriate limitations on further dissemination and obviously make it clear that the parties don't have access pending further order of the court, et cetera. All that needs to be in there until further order of the court. Okay, secondly, a case management order, I'm going to cover the basic framework of it, but it's a case management order. The plaintiff's operative pleading at this point is the second amended complaint. Ms. Moody has graciously agreed that they'll be filing an answer, reserve the right to file motions as appropriate, but they'll be filing an answer no later than 8/21. In all fairness, if I'm making the defense do that, plaintiff, can you file your reply to any answer within 10 days of receipt? Can't hear you.
Yeah. Yes, Your Honor.
Okay, thank you. All right. I'm going to give you the frameworks of what I'm thinking about concerning discovery, and you'll need to work out the language. I'm not ready to set an evidentiary hearing at this point. We're going to talk about that in just a second. But what I want to happen is once we get an evidentiary hearing or trial, whatever we ultimately call it, set, the party is going to be required to disclose exhibits and to disclose witnesses that they intend to call. And the parties are going to be able to conduct discovery concerning those witnesses listed and concerning the evidence identified. Not saying it very well, but what I'm saying is if the plaintiff lists witnesses for the hearing, whether they're reporters or employees of plaintiff or not, then the defense is going to be able to depose them where they otherwise are probably protected from being deposed. I haven't researched it, but I'm familiar with the concept of a reporter privilege, and the sheriff is not going to be able to just go take a deposition of a Florida Today reporter. But if you listen as a witness, I think it's fair that they do. Because you're saying they've got... Anyway, it's a little premature to cover all that as far as timing and all, but I think we need to go ahead and lay that out as discovery limitations. The... way I want to so I want to talk about the order to show cause issue, and I want to address that. But I want you to understand, without further briefing and based on the pleadings I have at this point, I have a second amended complaint. I don't have a motion for order to show cause. I don't have a motion for hearing. I don't have a notice. I don't have a motion for anything. So absent something else being filed, we're going to get the pleadings closed. As soon as the pleadings are closed, I presume I'll get a notice for trial. As soon as I get the notice for trial, y'all will call it to my attention specially, and I will get you set quickly. I'm not addressing an order to show cause or any similarly phrased pleading at this point because I don't have one filed. If you wish to file an order to show cause or a motion for some sort of preliminary relief, feel free to do that. Probably want to give me the legal support for it at the same time because we know it's going to be objected to. And we'll get a hearing on that. We'll address it. Alternatively, we'll get the pleadings closed by the end of August and probably be ready for an evidentiary hearing not too long after that, whichever direction y'all want to go. So, Mr. Burke, anything else we need to address at this point?
Yes, Judge, briefly, and thank you very much for giving us all this time.
Sure.
Something that may help you during the in-camera review of the video. The issue is this: whether Mr. Edwards was, there's no question use of force was necessary. There's no question he needed to be restrained. There's no question he was violent. The questions that remain between the reports and the evidence are exactly whether he was monitored properly, whether he was, after he was restrained, what his treatment was, among other questions. If there are 19 cameras in the jail booking area that have recordings, and none of them show Mr. Edwards, or let me amend that. If none of them could possibly show Mr. Edwards, then I don't want to say definitively, but those probably are not going to be relevant. And of course, Your Honor will have to make that decision. But there's argument, or excuse me, there's reports, there's testimony in these reports that employees at the jail could monitor Mr. Edwards from afar across the room in the jail booking area. But then there's also testimony by a corporal that says the windows were cloudy and she had to go look in the room. So that's the issue. We want to see his treatment from the moment he was delivered by West Melbourne Police Department to the jail to the moment he left for the medical center. And so if there are cameras that don't show that, or couldn't possibly show him, then those probably, without knowing what's there, those are probably not relevant. I offer that only to so Your Honor will know just to frame the issues here, so Your Honor will know what we're looking for.
That is very helpful. That's information I need to have foundation upon which to help me review. Ms. Moody, anything in that regard?
I just want to correct the record. I said 19 cameras, not 19 cameras in booking. There are 10 cameras in booking, and there are 9 cameras in the medical area. So I just want to make that clear. And then with regard to that, Judge, I think the question for Your Honor is going to be certainly number one, is it footage that comes out of a security surveillance system? There will be no doubt that that is absolutely what it is. The exemption will apply, and then next was the court will have to determine that being an exempt public record, is there any ground to any exception to that exemption that then would entitle the Florida Today to get access to those videos? So, and that is going to be a factual question based on the evidentiary hearing from our perspective as to what reasons would exist for the court to determine that that exemption should be vitiated by one of the exceptions. Certainly, the Florida Today has raised, their grounds for why they think that that exemption should not apply. But as the court observes the video, I don't believe there is any dispute or question as to the fact that it's footage that comes out of the security surveillance system. The question for the court will be, based on that, is there good cause to release the information to the public, to reveal the security features, the vulnerabilities and the strengths of the security system of the jail. And that will all be factual for the court to hear at an evidentiary hearing from our perspective, to be able to answer that question as to whether now where we stand in the course of the case and in light of the reports that have been made to the community, is there anything truly left to be said that has not already been reported on, produced, and that they have records, ample records from inmates who were witnesses to the event, the reports that they have had, volumes of information about. So I would say that the request, and I just want to say that I appreciate Mr. Burke narrowing the scope for the court. However, as it stands, the request from the court today is to produce all video, audio, unaltered, without interruption, from the arrival to the departure from the jail, and that entails 19 cameras. And my time estimate for Mr. Burke's clarification is actually about 2.5 hours. I had originally thought it was 2 hours. It's actually 2.5 hours, which makes up the difference between the estimate from yesterday and the estimate today. But it's got 47 hours of footage with various different camera angles that, the question for the court is, does the exemption apply? And if the exemption applies, will they be able to show good cause to defeat that exemption based on the footage that they're requesting to be produced, which from our perspective is hours and hours and hours of security-filled videos that, we're going to ask the court to ultimately deny that. But as the court reviews the camera, they're not simply requesting what Mr. Burke has just said. The request to the sheriff's office at this point in time has been for 19 cameras worth of footage for that 47.5 hours of time. So.
I am not presuming that watching it thoroughly in detail one time is going to ultimately answer all the questions for me, particularly in light of the potential argument that even if it is protected security footage, there's some waiver of that security claim because of other cases, other footage being released. I don't know how that's going to turn out, but the other question that's Moody I have for you is, of that 47.5 hours, has any of it been released up to this point to the today?
In response to this public records request, no.
Is there any of it that should be that hasn't been?
No, not at this point in time.
Okay. That's it.
No.
I accept that. All right. Mr. Burke, I'll let you wrap it up. Anything else?
Yes, Your Honor. Thank you so much. I disagree wholeheartedly with Ms. Moody on the question of whether there's a dispute about this video coming out of a security system. That's not the standard. The exemption talks about whether the recording would reveal the security system. Now, what's a security system? Is that something that's monitored real time, or is it something else? In this case, I don't believe there was any real-time monitoring. And what it then becomes is not a security system, but a performance system. It's there. It's a tool to determine public agency performance. So we do dispute that wholeheartedly. And perhaps in the briefing, well, I'll end it there, Judge. I appreciate your time very much.
Yes, I would appreciate that issue briefed.
Okay.
That would be very helpful because I'm not sure I completely understand the distinction you're seeking to make there. So I would appreciate that.
Agency after agency since 9/11, and there was a fusillade of legislation after 9/11, reactionary in my opinion, but agency after agency has hid behind this security system exemption to avoid being held accountable for misfeasance or malfeasance. Case in point is the Parkland shooting in Broward County.
Okay, this isn't helpful.
Okay.
Let's wrap it up. I would appreciate case law to assist me in determining what is security system, security footage, what are the parameters of the protection under the statute. Can you each get that done within 10 days?
Yes.
Okay, we're going to hang up. Thank you all very much, and look forward to hearing further from you. Have a good day.
Thank you, Your Honor.
See ya.